Okay, today we're going to talk about partnership, and we'll start with the definition, and the definition tells us the elements of partnership. So what is it that a partnership is, basically? It's an association of two or more persons to carry on as co-owners of a business for a profit. And so key to that are the sharing of profits or losses. Sometimes some people want the losses. If they have another high income and they enter into a partnership, they might want to have losses to offset some of the money that they make from their high income. So, this was very popular. I think when I was young, I knew several of my friends, their parents were doctors, and every one of them had a farm. And, the farm was a write-off, apparently, for them. They didn't make any money on farms. They weren't interested in being farmers, but it was a write-off for them because they were making a lot of money as doctors. And they figured that eventually they would make money when they sold the farm, because they were just basically speculating in real estate, weren't they? And so that was it. So, and a lot of them would also enter into partnership with that kind of ideal. So they enter into a partnership where they would own maybe some apartment buildings with other people, and somebody would be managing the apartment building. The doctors were not managing the buildings, that they were engaged in that. And at first there might be a lot of, because building the apartments or acquiring apartments would be very expensive. They would have losses to offset their income, and eventually those businesses would turn a profit, which would be added to their already profits in that case. And so they would always be looking around for some way to avoid paying taxes. I don't think it's really that much of an issue now, because we have so diminished the amount of taxes that people who make a lot of income pay. And so I don't know that it's the same thing going on. But anyway, that's the way it was then when I was just a little child. I'm talking about when I was in grade school. I knew about this stuff. My father was an accountant, so he'd tell me these things. And I said, okay. I think he thought I would grow up to be an accountant. Instead, I grew up to be a lawyer, much to his disappointment, I'm sure. Now, I understood he at one time thought about going to law school. And when I was in law school, one time he threatened to go to law school. And I said, yeah, go ahead and do it. But I knew he would make a terrible lawyer, because he was so exact. And he'd just be driven crazy by the ambiguity and the vagueness of the law, that it would not be for him. I mean, I know lawyers who are very precise and they do a good job, but I think they're not really in the spirit of things. So anyway, let's go on. So basically, the persons. So the UPA, the Uniform Partnership Act, provides that for purposes of a partnership, a person can include corporations. So yeah, it just reminded me, I seen recently somebody was saying that corporations are not persons, and but they are under the law, because we define them as being as such. So this happened in 1887, I think it was, the Santa Clara case. Anyway, some states do not allow corporations to be partners, so those are old-fashioned states, right? How stupid of them. Anyway, following are not profit. So a partnership requires that you're sharing profits or losses, but the following would not be treated as profit. Installment payments for a loan. Okay, that would not be. So you're in a banking business, that you're not going to have a partnership there. You don't see that. You see partnerships with lawyers. You see them with dentists. You see it with people owning restaurants and engaging in real estate deals. Real estate brokers, and you see it in this kind of thing. So it's really pretty much a Main Street kind of thing. So at the upper levels you have the corporations. At the national level, you have corporations that generally run everything. You can have a partnership that's a national partnership, but I just don't know of any yet currently. Anyway, the following are not profit. Installment payments for a loan. So if you're making your money that way, that's not a partnership. Wages paid to an employee. So you could have a co-op where you, with other workers, you all agree to co-own a business, and that's a co-op. But that's not considered to be a partnership. You're paying yourself wages each person gets a wage, each person owns a share of the business, and maybe gets a share of of the whatever profits are made in the business, but the wages that they get paid as employee are not a profit. So, you know, basically you would need to have a situation where the person was not paid any wages. And now this brings up an interesting kind of case. What do you call it when a person, an employee, talks his boss into continuing his business? His boss wants to retire, and he talks his boss into continuing and says, look, you don't have to pay me any wages anymore. I just take a share of the profits, and I'll run the business, and you go ahead and go down to Florida, and you'll get a share of the profits. We'll split everything 50-50. He's no longer an employee. He's not taking a wage. He's taking a share of the profits. And if the boss agrees to that, he now is in a partnership, and therefore that employee now is a co-owner of the business. And there's an actual case on that we studied. And you know, so you know, sometimes people inadvertently create a partnership. I don't think the person who owned that particular business intended it was a floral business. I think it was, you know, they sold flowers and did, you know, yard things, grass and you know, all kinds of outdoor things. They would sell plants and they would deliver it. And I don't think that the person who started that business intended to have a partnership, but that's what he wound up with. And why did he agree to that? Well, it seemed a good thing to him. He wouldn't have to worry about the paying the guy a wage, because you know, he's just going to be taking some of the profits, so he'll have to make a profit, and that means that he'll be getting half the money and the other guy will be getting half the money, and he doesn't have to do any work. So and that's what he wanted. He was getting what he wanted, but he didn't realize that in doing so, he was giving away half of the ownership of the business. So the business has an ownership interest, as you know. Businesses actually have, as part of their goodwill, the ongoing concern that is the business. In other words, they have repeat customers and they have a status as such, and so you even list that as an asset when you sell that. So interestingly, that was a case where the former employee was able to excessively assert that he wasn't, the guy couldn't just end the business because he was a partner of his. And so they had to dissolve the business as a partnership, which would mean that he would get a half interest in everything that was owned by the partnership. And what the boss put in was the business and the building and the equipment and the inventory. That was all part of what the boss had put in there. And what he had put in there was his work. And you can get, even in a corporation, you can get shares for doing work for a corporation when it's formed. So promoters sometimes take some degree of shares for their work as promoters, and it's people who form the partners, the corporation. Same thing with the partnership. If you go into a partnership, one guy might be getting his share by donating a building or equipment or inventory or land or something that's physical, and another guy may be getting his share by doing the work. So you go into a business, you see businesses that maybe partnerships that are maybe you know, they have in Hawaii, they have these boats that go out in the harbor, and these boats are sort of entertainment boats. You go out into the harbor, you buy a ticket to go out into the harbor, and they feed you a dinner and they give you a show, and then they bring you back to the wharf. And I went to one of those, and it's very entertaining. And but I understand that a lot of those are partnership with the captain who's running the business basically, and he's in charge of everything. You know, he gets his share because he just does the work, both this work, the work that he does before they start out, which might be getting a boat and putting it in shape, and you know, buying the inventory and getting a cook and getting entertainers and getting contracts. He does all that work to begin with, but then he's continuing to do work, which is maybe some of the reasons why he's getting shares. And so you have that. So you can do that either in a partnership, or you can do it in a corporation, or you can do it in an LLC, or you know, LLP, or an LLP. You can do it in any of those things. In a limited partnership, even, I suppose you could do something like that. I mean, that might be exactly what you do in a limited partnership, where one guy wants to not be liable, and he just simply doesn't do any of the work, but he puts up substantial money. Anyway, so the following are not profits. We said installment payments for loans, wages, annuities paid to a spouse of a dead partner. So sometimes when a partner dies, his spouse is left without income, right? Because he's been a partner, he's been making his money as a partner in the business. Maybe he has a salary, and maybe he also gets a certain amount of the profits each year because they distribute the profits each year. Usually this is typical in a partnership, unlike a corporation, where you oftentimes have retained earnings of substantial amounts. Partnership, that's not so much so. And so, there's oftentimes an agreement that a spouse would not become a partner. It's understood that way, and it's actually, if it's correctly written up, it'll be clear in the partnership agreement that the spouse will not become a partner. You don't want that to happen, especially in professional partnerships like lawyer partnerships or doctor partnership, because you're getting somebody who's maybe not even trained or isn't experienced in it. Even if they're actually a lawyer, maybe they never practice law. So some people go to professional schools, get a degree, and get a professional as a husband. So this is an old way of doing things. I realize nowadays that most women who go to law school do practice law afterwards. But back then in the day, they didn't. Oftentimes they just simply married somebody and just upward mobility that way, right? Anyway, so that would be it. So also is not profit is rent paid to a landlord, so that's not considered to be profits. However, if you've got a real estate business, you can generate profits that way and pay those out to owners of the real estate business. So you can create a corporation that does a business, or you can create a partnership that does business, and so you're not getting paid the rent. The business is getting paid the rent, but then at the end of the year, you're maybe getting a share of the profits that are made. Or you might even get it more often than that, depending upon how they set it up. Anyway, payments for sale of goodwill. The goodwill is, like I said, in a restaurant business, it's the fact that you're there and you got regular customers coming in. Same way with the apartment building, it has goodwill in that it's got a steady amount of people who are living there maybe for years. And so you're maybe familiar with students who just coming in and renting an apartment for when you're there, but there are people who live in apartments all their lives, never maybe gathering up enough money to, or never maybe wanting to have an actual house and all the responsibility that comes with that. Anyway, so those are not profits. These are all in the PowerPoint, which you'll get. And one of the most common things, or one of the things that's most important in a partnership, is common ownership. And so I like to have it made clear that that's the case when I do a partnership. If I'm creating a partnership for some people, I want them to both know that anything they donate into the partnership for use by the partnership is probably going to be considered part of the owner, to be owned by the partnership. And they can make it clear otherwise, but they need to write the provisions very specifically on money, on items like, let's say, a house that is being used by the partnership. Is this being used some way? And if in fact it's not meant to be considered partnership property, they probably would want to have some sort of provision that there would be some sort of payment made for the rental value of that building if it's being used in the partnership. And so common ownership usually does not automatically result in a founding of partnerships, even where the owners share rental proceeds. This is true, because rental proceeds are not profits. So, so there you go. Partnership as an entity. States, all of them allow, all states allow the partnership to sue and to be sued. Some allow the partnership to sue in its own name. A lot of them maybe require the individual partners to kind of all join together and sue. That's kind of messy, so it's probably not good to organize the thing that way. So federal courts allow suits both ways. Marshaling of assets. Marshaling of assets is that if you do go out of business, you will first pay off all the debts. Bankruptcy. A firm may file in its name, discharge is granted in its name. So, is that the best way to do it? I don't know. Is it just the partnership that's bankrupt, or are the partners themselves also bankrupt? So, I think if you look at the movie Civil Action, this law firm, and they all go kind of bankrupt. And before they go bankrupt, as they're trying to finance this lawsuit, which they got into, which they shouldn't have gotten into so heavily, they were not able to get loans. They had loaned themselves out. That is, they'd gotten as many loans as they could, but they needed to raise more money. And in order to get a loan, they started pledging their own individual properties. So I would imagine it might have been in their interest to file the bankruptcies in their names and not just in the partnership. You can file it in the partnership name, or the individual partners can file. And so then that would be each individual partner would have a separate case, because they'd probably have separate degrees of indebtedness. I mean, they might have separate assets, and so someone might be more financial. Someone may not need to file bankruptcy. So bankruptcy firm may file in its own name, and the discharge is granted. If that does it, then it's going to be granted in its name, and therefore the debts that will be discharged would only be the partnership debts. Because the partners are otherwise liable for the debts of the partnership if the partnership can't pay them. So if there's not enough money to pay off the partnership debts, each of the partner will pay his share, and it's based upon what he would have gotten as profit. So if he was a 50-50 partnership, he'd have to pay 50%. If he was a 25% partner, then he would only have to pay 25%. Let's say he's in business with somebody and he's a 20% partner and the other guy's 80%, then the 80% guy has got to put in his 80% because that was what it was. So anyway, bankruptcy. So discharge is granted in its name in that bankruptcy. Conveyance by a firm is valid. So the firm can convey its business, its assets, and it can do so validly. Taxes, unlike a corporation, there's no double taxation. A corporation will pay corporation taxes on its profits. Nowadays that's been very much diminished, but they still in many cases have to pay that. And if they can't figure out how to basically otherwise report their income. So I don't want to get into that. That's something for you to talk to your accountants about. But no double taxation. The firm does not pay taxes as an entity. So each partner, the income flows through to the partners. Each partner pays to his degree of profits. And if you're working, let's say I was working in a law partnership. Me and my partners had this law partnership, and I got a check. Just so happened to be a check I got for representing a client through a fund that was funded by the federal government. So this was a fund for indigent people who couldn't afford a lawyer. They could get money to have representation, and lawyers could sign up with this legal aid society to represent these clients. And I signed up, and I had this client, and I made an unusually high amount of money for that kind of work. It was about $5,000. They're typically only getting like $1,000, but it was a much drawn out case with a lot more work, so there was some justification as to why I got $5,000 on that case for representing this indigent case, because there were like, 20 boxes of transcripts that I had to read before I could even begin to make my arguments in court. I had to go through all the trial, and it was a big, drawn-out drug trial. So I got that money, and at the time I was in a partnership, so I took that check and I deposited it in the partnership account. And then about a year or two later, I got a mysterious letter from the IRS saying that I had made a certain amount of money. It happened to be $5,000. And I said, they're probably talking about that money that they paid me. It's the federal government telling me about this thing, and they're saying I didn't pay taxes on it. I didn't pay taxes on it because it was paid into the partnership. And although the partnership flows through, I pay only on the profits, and if there are losses, I can deduct losses. So I didn't pay any taxes directly on that $5,000. It didn't amount to that. So anyway, that flows through, like I say. And if you're in a partnership, if you're making money in the business of the partnership, in this case it was law business, I have to put that into the partnership. My partners didn't know anything about it, but it was money I made, doesn't matter, they didn't know anything about it. If I'm doing legal work, I've got to either tell them about it or get them to agree that they're going to allow me to do it and take all the money myself. So I just simply deposited it in there. I didn't even tell them about it until later. Anyway, so a firm must file an information return. Even though the partnership doesn't have to pay taxes, it has to file an information return just saying what kind of business they did, what kind of money they made, and what kind of expenses they had. They have to file an information return is what it is. Partners pay taxes on their receipt of distribution. They can, so that's their degree of profit. So like I say, it flows through. They can also claim losses if the firm has losses. And a lot of new businesses will have losses in the beginning. Like I said, some people want those losses. I've got this high income and I'm paying so much taxes. Yeah, I'm going to take a loss and I'll lower my tax on this year. And maybe in the future I'll have more money, but yeah, I'll just, and in a way, the history of the thing is that year after year I saw the taxes diminishing at the upper levels. So, it seemed to make a lot of sense for people to go ahead and take losses early rather than trying to spread them out over years. Anyway, formation of a partnership. The most common way would be by an agreement, a partnership agreement. Technically speaking, it's not really a contract. Although not generally required to be in writing, the partnership agreement is not generally required to be in writing. It should be in writing and setting the rights and the duties. You're well advised to have it in writing. I mean, it's an important document. So I got a story about people who didn't do that. A client of mine came to me and told me that he had been in business with a friend of his for, I think at that time it was only like 6 months, but they had never signed an agreement. They didn't have an agreement. And he asked me to write him an agreement. I said, okay, when can I meet with you and your partner? He said, oh, you don't have to meet with your partner. I'll tell you everything you need to know. And, you just ask me if you have any questions. And I said, well, I can do it that way, but it's better if we all meet so we can discuss it. And he was adamant, didn't want to do it. I found out later his partner didn't have any idea of having an agreement, didn't want to have an agreement. As a matter of fact, we wound up in court where I had to prove the guy was a partner. He didn't have an agreement. And in his case, it was very important because of the parole evidence rule. He had acquired an interest in the leasing of a building out of which they were running a restaurant. And he was not on the lease, so his partner brought that into the business as part of his contribution to the business. And my guy was not part of the lease originally. And if you're entering into a business and acquiring an interest in land, yeah, the rules say you need to have that agreement in writing. That's a contract rule, but it applies in partnership situations. Even though they're not technically considered to be part of the contracts themselves, the parole evidence rule does apply to them. Okay, so duration, okay, should be in writing. And there are reasons why other reasons why you want it in writing. In that case, the really big problem was that Sam, who had been in the restaurant business, thought that he should be in control of the business. So he saw himself as being a 60% partner and saw his friend, the economist, as a 40% partner. And so they must have discussed this over drinks or something. So they were longtime friends. They'd gone on vacations together. They'd known each other since college, and they'd been friends for over 10 years. They'd gone on vacations. Their wives knew each other, and they all got along very well. But then they went into business, and it all went to hell and back. Anyway, they didn't sign an agreement, didn't have an agreement. They had discussed it, and they had agreed to be partners. That I know, because he admitted to me that when I met him. But that was, when we were discussing these matters, and therefore it was not admissible in court because technically you could consider it to be some sort of him, and his partner were trying to get him to agree to, settling this issue about an agreement and having an agreement. So it was when you're in negotiations like that as a lawyer, you cannot use that as evidence, and you cannot testify as to that. Even though he told me that yes, they had agreed to be partners, but what he told me was he was a 60% partner. My client was a 40% partner. My client said, no, I put in just as much money as he did, and I'm a 50% partner. and I'm doing the same amount of work as he is. We're both spending a lot of time working on this new business, and I'm a 50% partner. Well, I can understand his point. His point was that he wanted to be in control of the business because he had experience in the business, and my friend did not have any experience in any kind of business. All he had done was study economics, so he had a very theoretical point of view on these things. Didn't have very much practical knowledge of running a restaurant. He knew how to cook, as they were both sharing the cooking. He was usually running the register because he was good with numbers. He was actually doing the books for them, but his partner, who had experience in the restaurant, thought he should be making all the decisions, and so that's why he thought he should be a 60% partner. Now, I could have solved that for them if they'd come to me in the first place, or if he had been willing to talk about it. I could have solved the whole problem. The solution to the problem is to keep their share of the profits 50-50, but to give control to Sam. And my client, I think, would have agreed to that after I talked to him, because there were good reasons why he should. And he was a reasonable person, after all. So I think something could have been worked out. And as it was, because they entered into an agreement without that, if I can get that agreement to stand up in court, despite the parole evidence rule, which is my big problem in that case. Once I could get that to stand up in court, once I could get the court to recognize it, or to hear evidence about it, and decide that, well, I'll explain that to you in a minute. Once I get him to do that, then it would be a 50-50 partnership all the way down. Because there are provisions, if you don't put your agreement in writing, but you're found to be sharing profits for a profit, you're co-owning a business, and you're running a business for a profit, as they were doing. I mean, they both had contributed money into establishing this business, which went into the inventory mostly, and also equipment. So they both had established that. He did bring in a lease, which the partnership was going to pay off, so it wasn't like he had given really much of an asset. What value that might have been for that. Or we could have maybe agreed to the 60-40, which my partner didn't want, or what my client didn't want. Anyway, so that's why you want to do it, because if you don't do it, the law will apply the terms that it says are the standard terms of partnership, and it's going to be 50-50 all the way down. And it's maybe not what you want. And you maybe want a different understanding. And it doesn't necessarily have to be, it could be 50-50 on profit, and control could be divested differently. So partnership by estoppel. If a third party reasonably and detrimentally relies on representation of a partnership by a partner, that a non-partner is a partner, then the non-partner will be deemed an agent of the partnership, and the partnership will be liable for his acts. Now, what's it mean for the third party to reasonably and detrimentally rely? For reasonably would be, there would have to be some indication, or maybe some silence on the part of the party who's saying that it's not a partnership. So let's go back to Tony and Sam. Let's say Tony says it was not a partnership. We never agreed to a partnership. So he's completely denying it, which is what he basically wound up doing in the court, although not on the stand. So basically, if he's sitting there and his bartender tells some guy that he's a partner in this business with some other person, doesn't identify the person, but he later finds out that the person who was the partner was sitting right next to him on a stool, and he's negotiating some sort of deal, and later the partnership tries to get out of the deal by claiming that there was no partnership, that he was not dealing with somebody who had authority to enter into that kind of a deal. Well, that there you have then the person being reasonable and thinking that this guy was a partner, because if he wasn't a partner, surely this guy would have objected to it, or should have objected to it. So you can't sit there silently like a potted plant and take some advantage of the person. And that's what it is, right? So reasonably, he should have known that there was a person representing him as this, and that if he wanted that not to be the case, he needed to speak up. So, and detrimental reliance comes in that the guy did some work, prepared, maybe, what it was is he delivered a shipment of liquor, which they took in, and they only wanted to pay for the liquor that they used because their business went out under, and so they just want to pay for the liquor that they used, not for the whole shipment. And he's saying, no, I want to get paid for all of it. That's got to be decided by the bankruptcy court, basically. But as to whether or not the partnership owes that debt, I think the partnership might well say, well, it owes the debt, but it may be largely discharged in bankruptcy, especially if they can return the liquor that was delivered. So those are other issues. But you can see that partnership by estoppel means that a person could be stopped from denying the partnership because he reasonably relied, and this was detrimental in that he went to some expense and he hasn't recovered that expense. That's why you want to give him back his liquor. And as to the liquor that you sold, you're going to have to pay for that. You used it up, and so you have to pay for that. You got to pay for the ones that you actually sold. It becomes more like a consignment that way. So a consignment is where you take something for sale, and then you only pay for it when it's sold, and otherwise you return it to the person that brought it to you for holding for sale. That a non-partner is a partner. Then the non-partner will be deemed an agent of the partnership, and the partnership will be liable for his act. Even if it's not a partnership, he'll be deemed as an agent, if not a partner. I mean, so basically that would be a partnership which actually lacks the second partner maybe, but but it'll be treated as an agent for the other fellow. Management and voting rights under the EPA. So UPA. So these are what the UPA, Uniform Partnership Act, provides if you don't put your agreement in writing. As I said, equal vote management rights. So take your number of owners, divide them up equally, and what you're doing there is maybe ignoring how much each of them contributed, or what the contributions of each of them was. So you probably want to have an agreement so you can give them maybe equal shares, equal rights of management, and also equal voting rights. You may not want them to have equal voting rights. Majority votes decides most issues. It's another provision. And the following require a unanimous consent. So when you're in a partnership, there's some things you can't just do as an individual anymore in regard to the business. Altering the essential nature of the business. Let's say one of the partners decide, we opened this partnership as a law business, but I think we make more money as accountants. Each of us have an accounting degree. Well, let's just do accounting business and forget about doing law business. Actually, I think you should probably do both of them because you probably make more money that way. But let's just say that's the case. So you're changing the essential nature of the business. You're changing it from one kind of business to another kind of business. So maybe you are dealing with air freight, and but you're not making a lot of money in air freight. So you decide to also start doing business as trucking for business. So you're doing trucking and air. You're changing the essential nature of the business because originally it was just supposed to be air, but now you're adding trucking, and that may be a good thing, but all the partners have to agree to it. So you need to have unanimous consent of all the partners because each of them entered individually into the business thinking that you were going to be doing air business, and so they have a right to say, no, that's not what kind of business I want to be involved with, for whatever reason. Or another one is you start a business as to sell magazines, but just not making much money selling magazines, so you decide to sell porn and sexual toys. Okay, and the Reverend, who was perfectly happy to be a part owner of a magazine business, a magazine store, doesn't want to be involved with this kind of a business. So obviously, this is one of the reasons why you have unanimous consent required for altering the essential nature of the business. Admission of new partners or altering the capital structure. So, so one partner might want to add a friend of his to be a partner, but maybe the other one doesn't for some reason want to add that individual. And he can just say, no, we're not going to do it. So he has a veto. So yes, you have to have unanimous consent to add new partners or to alter the capital structure. One of the partners wants to go out and make an additional loan to the business and acquire more capital for capital improvements to the business. Maybe buying more inventory. He wants to buy more inventory, so he wants to go get a loan and restructure the financial structure of the business thereby. You have to get unanimous consent. Okay. Assigning partnership property. So let's say you got some partnership property, you're not using it, and you give the right to somebody to use it. It might be land, so there's a farm and a farmhouse, and you're using the farmhouse, but you're not otherwise using the land. Can you go and assign the right to farm that land to some farmer who's going to sharecrop it? You can't without getting unanimous consent. You can if you get unanimous consent. That also be, of course, would be changing essential nature of the business, maybe, probably. Confessing judgment against the partnership. Confessing judgment is when you go to court and say, yes, Your Honor, we are liable for that debt. For whatever reason, whether it's tort or contract, we are liable for it. That would be confessing judgment. That also has to only happen with unanimous consent, so it's not a matter of majority voting. In these cases, it's not a matter of majority voting. It has to be unanimous. Amending the partnership agreement. So if you don't have an agreement, there's none to amend. But if you do have an agreement, you can't change those terms without the unanimous consent of everybody who signed it. You can understand why. Partnership interest, share of the profits and losses, return of equity upon termination. So what do you have a right to get? You have a right to get whatever monies and whatever values you put into the business. And so you get a return on your equity. Assignment of the individual partner's interests. S&E is not a partner. No right to manage, vote, or demand an accounting. Okay, so you can, if an individual assigns his partnership interest, it's not going to affect the partnership. That S&E cannot claim any right to manage, vote, or demand any sort of accounting. Can't take a look at the partnership books because he's not a partner. He's an S&E of a partner. That's all he is, and he can't demand that. Only the partner would be able to access that, and it might be a violation of their agreement and understanding for him to share that information. It probably is that, and maybe so because of state law, maybe so because of the agreement that they've signed. Creditors can obtain liens on the partner's interest. Okay, yes, so creditors can obtain a lien on the profit that the partner would be entitled to. I don't know about the losses, they don't want that. Corporation, compensation. Salaries must arise out of agreement. A partner cannot claim compensation for work done without employment status. So it has to be, he has to be, in a sense, hired by the partnership. He's a partner, but if he's going to get a salary for working in the partnership, he has to do that. He has to, it has to be a formal agreement where he's identified as an employee, and then he can collect some sort of salary. And this is very commonly done. And it's not a problem. But you need to set that up in the very beginning, and so it becomes part of your agreement as you start off. Or you can do it later by an addendum, but it's probably better if you're going to be doing it all along. Probably you do it right up front. Anyway, accounting rights, access to the partnership. So a partner would have right to look at the partnership book, access, and to look at the records of the partnership. Not only can he inspect them, but he can make copies of them. Okay. EPA provides a right to formal accounting to enforce rights pursuant to articles of partnership. So he might be able to say, well, I want the accountants to provide me with any sort of financial document. Give me a list. I want to know what the profit is, so I want to get an earnings statements. I want to know what the assets are. So give me a balance sheet. And I want to see how whether the cash flow is a problem or not. So I want a cash flow statement. So he can ask for these kinds of formal accounting documents to be made up if they're not already made up. If they're made up, he can just go, I want to look at it. If you already got it, I want to look at it. And if he thinks they need to do a new one, then he can demand that too. Rights under the EPA, other rights arising independently. So any rights that are specified in the EPA would be your rights under a partnership agreement. Partnership property, all property acquired by the partnership. So if you're using partnership funds, either profits that could have been distributed, or whether it's just some sort of assets that maybe it's cash flow that wasn't otherwise committed to paying debts, or that if you acquire property with partnership monies, then all the property acquired by the partnership is basically owned by all the partners. All property acquired in the name of the partnership. So if you buy it with the name of the partnership. So you may actually want to have every partner have, let's say it's a professional business like accounting or it's a lawyer, and you decide that everybody should be getting a new computer. So you buy out of the corporation, or no, out of the partnership funds, you buy everybody a new computer so they can do their business with that. And this is being bought by the corporation in the corporation name, so it's partnership property. So even though each of them gets assigned a computer, technically if the business goes bust, it's not his individual computer. It's owned by the partnership, and therefore, you know, it may be sold off in the course of bankruptcy. Okay. Partnership property can be assigned except for the purposes of the partnership. You know, so a partner couldn't do that. I think the partnership could actually assign it, but not an individual partner. What it is. Partners' duties. Partners are agents and have all of an agent's duty, including they have a duty to account for property. They have a, you know, so let's say I knew a guy who had a fishing partnership, a fishing supply partnership. So they would supply baits and hooks for people who were fishermen and reels, and they had a company-owned boat where they would show prospective buyers their wares. So these were buyers who would sell actually fishing equipment. So they were selling to others their products. And so this was property. Now on the weekend they might use it, and if so, they have to take care of it and have to, you know, make sure that it's not damaged. And if there's any damage, they become responsible for it. And they have to tell them that they're going to be using it on that weekend. So, you know, so it's just not disappearing. Profit, you know, they have to account for profits of the business. So if I do work in the law business, you know, and I made some money, I've got to account for that. I have to account for benefit derived from the conduct of the partnership business or use of its property. All that I have to account for. I have to usually put it into the bank account. It's the simplest thing to do. Refrain from competing with the partnership or dealing with an adverse property. So as a lawyer, I couldn't then do work for another partnership unless, of course, it was generating business money for my partnership. You know, then I could maybe do it, but not. I can't compete with the partnership. You know, I can't be like in two partnerships and be competing with myself, you know, or my two partnerships. So, duty of care is a duty to diligently do work and avoid the intentional wrongdoing and criminal acts. So there's a duty to get the work done. Partners' authority. As an agent, partners have a presumed authority. Concepts of actual and apparent authority apply as well as ratification. Any act done within the scope of the partner's authority binds the partnership. So you want to have this authority spelled out in the partnership agreement. An act outside of the scope can only bind the partnership if ratified. So let's say that it was the buying and selling of antiques, and each partner had the right to buy antiques up to the value of $5,000. And then one partner comes on a really great deal, but it's $10,000. And he entered into it. He didn't have the authority to enter into a $10,000 purchase, but you know, the partners could ratify that, and he has to tell them what he's done, and they can refuse to ratify, in which case he's on the hook for the money. Knowledge of a partner is imputed to all. If you know one partner knows something, all of them that. So if he commits a crime, it's thought that everybody knew about the crime, and therefore should stop him. And you might have criminal liability even. Partners' contractual liability. Partners have personal liability for partnership debts and must pay when the partnership assets are exhausted. Okay, so that's what I mean. If they go into bankruptcy, you're maybe going to have to pay. It's a risk of doing business as a partnership. Now, if you form a corporation, you don't have that, right? Because you have limited liability. You don't have this limited liability in a partnership. Unless it's a limited partnership, and then only the limited partners have the limited liability. There's always a primary partner who's not a limited partner, who's actually just a partner. And in that case, he is the one who's taking the risk of the business failing. In some states, partners have only joint liability for partnership debts, so they only owe for a certain percentage of the debt, you know, which is probably not a very good rule. Other states make them jointly and severally liable for the debts of the business. I'd rather be doing business with that kind of a partnership if I'm doing business with a partnership, right? And so I think most states would probably have that former kind of thing where, you know, they're jointly and severally liable. Incoming partners. Absent an agreement to assume all partnership debts past and present, the incoming partners are personally liable only for obligations incurred after their entry into the partnership. They may, however, lose their capital contribution should the partnership become bankrupt. Okay, so if they agree to take on the debts of the business, which sometimes they oftentimes do, then they're liable for the whole debts. Otherwise, they're not liable for debts that were accumulated before they entered into the partnership business. So if you're joining a partnership, it's good to find out what their financial situation is. You want to know that before you become a partner. Dissociation of a partner. So this is when a partner is no longer going to be a partner. He's going to go work maybe for some other firm. Usually entitled to have the partnership purchase his or her interest. So, you know, you have an interest in the partnership, and you probably want to get paid for leading the partnership, basically. You have an interest in the future profits of that, and so you want to be, and the current profits, and so you want to be paid for that. Although the former partner has no authority, apparent authority will arise if the partnership doesn't notify creditors, customer clients, and appropriate government offices. So if, you know, this is very silly, if you're in a partnership, let's say it's an accounting partnership, and some guy's had some of your clients, and he's done work for your clients in the past, they still think he's a member of your partnership, and so they hire him again, and let's say he screws up, you wind up becoming liable for that, even though he's no longer a partner, because you didn't notify him. So usually in these partnerships, you usually have to put out a notice publicly, and what you want to do is take your files and send out a notification, a letter to everybody that, you know, the business has done business with, and tell them, just in case they know, you know, they don't know it, that this person is no longer going to be a partner. If they know it, then that would be an out for you if you could prove that they knew it already, and therefore you wouldn't have needed to send them one. But you don't want to rely on it. You just send one out to everybody. And also in things like lawyers, you usually would publish it. And oftentimes a court would have, court where the partnership would be doing a lot of business would have some sort of legal newspaper, and you put a publication in the newspaper, or it'd have a bulletin board somewhere where you put a notice up there for people who could look and see it. And you maybe put a notice in the local papers about somebody leaving. So this issue, although the former partner has no authority, there's a possibility that his liability may arise from his pretending that, because he will be seen as having authority, and maybe even entering into a business. So wrongful dissociation, this would be a breach of a partnership agreement. So, you know, sometimes the partnership is for a stated term. Then dissociation is wrong if premature, so you can't leave. You agreed to be a partner for 3 years, you can't leave before 3 years are up, unless you get them to agree to that arrangement. So that you can always change a contract like that, or a partnership agreement, you can change it, you know, but that has to be done by all the parties have to agree to change. The dissociating partner is expelled by a court for misconduct. Okay, so that's it. You still need to, in this case, send out notice to the clients and to the general public, but you don't, all other things associated with dissociation are taken care of because he was expelled by that, or he declares bankruptcy, in which case he's not, is no longer financially responsible. Partnership termination. This is a process that involves both the dissolution of the partnership business and a winding up, during which debts are paid, assets are sold, and the residual is distributed. So what's the difference between dissolution and the winding up? Well, dissolution, you declare the partnership to be gone. It's no longer a partnership. We're no longer a partner. We're not doing partnership business. But winding up is where you pay all the debts, and any business that needs to be done. If you have are obligated to deliver something, you got to deliver it. Or if you have property that belongs to somebody else and they have a right to take it back, you need to deliver it or allow them access so that they can do that. And so you basically pay off all the debts, and any assets are sold. The residual is then distributed. Okay. So various ways in which dissolutions occur, I'll go through that. Notice, all partners must be notified either expressly or impliedly. So not only do you notify your clients, but you also notify all the partners. So this is the last slide here. Winding up. Complete transaction has begun but not completed as of the date of dissolution. So you have to complete, like I said, shipment to the parties that you promised shipment to. Payments of third-party debts that you owe as a partnership. Refund of loans or advances to those partners who made them to the partnership, so they get their money before you distribute the profits. That may cut into the profits. Return of a partner's capital contribution, distribution of profits in proportion to agreed shares of the partners after the capital contribution. So the capital contribution and loans and advances get paid before the profits. Okay, so thank you very much for listening to my speech, my lecture, and I hope you do well. Thank you. Next time.